And is there anything we can do before then?
Huber, he's gonna shoot, he's gonna let. You guys locked
He's
up.
on the line, he's right in line. Mr. Webster.
Are the lawyers here on the civil matter? Everyone here? Everyone here?
I haven't seen it.
Okay. When everyone's here. When everyone's here, just let me know. Good morning. Ms. Leggett, will you be asking for a PSI?
No, Judge, this is the case we talked to you about last week.
I know, there was a lot of cases last week, I just wanted to know. You don't want a PSI?
No, Judge, it's been agreed.
Okay. That's right. I got it.
Are you ready?
I think he's here.
That's at the time.
Just want to let you know, bring that up.
Ms. Leggett, do you have a case number for Warren County case?
I don't, Judge. I tried to find it on Mr. Gramke's paperwork last week and I couldn't sort out what it was. I can try to
Because we
find.
can't run into something that, you know, we don't have a case number. Warren.
I'm,
All right, who's that?
Green box, you guys.
All right, this is a matter of State of Ohio versus Kareem Foster, case number B 220545. Mr. Jeff Kutcher for Mr. Foster, Mr. Gramke for the state of Ohio. This matter is on today for plea or trial setting. Mr. Kutcher, we already have a trial date and a final pretrial conference date. They are April 17th and April 6th respectively. Have you received all the discovery?
I have not, Your Honor, but that's not the state's fault up here, I don't allege. There is a related OVI in Judge Peck's room that is the exact same incident as this is. And I'm owed discovery down there to see whether or not my client in fact consented to the blood draw that might show that he was intoxicated. The charge.
What does that have to do with improper handling of a firearm in a motor vehicle?
The charge here is it's improper handling because he's intoxicated, not because he's not because of any other reason, simply because he's intoxicated. So he's allowed to have a gun. There's no CCW. And so theoretically, we would resolve the intoxication issue in Judge Peck's room. However, I've talked to the state this morning about a plea deal where I think what's going to happen now is my client's going to plead to being under the influence of marijuana in Judge Peck's room, and we'll come up here and we have a resolution after that happens in Judge Peck's room.
Okay.
So I expected a plea in Judge Peck's room this Friday, March 3rd, and I wondered if we could come back here for a plea date before our final pretrial.
All right, well, we can in about a few weeks, because I'm getting ready to go into a trial. So, Ms. Howard, can we just put maybe a pre-trial on? Mr. Grant, anything you want to add?
No, everything was accurate.
Okay, let's put it on for a pre-trial in a few weeks.
How about March 15th, Wednesday, March 15th?
That's perfect, thank you.
All right, so we'll come back, Mr. Kutcher, Wednesday, March 15th at 9 a.m. and for a pre-trial, but obviously if your client wants to plead that day, that'll be fine. Now, is he here today?
He's not, Your Honor.
Are you waiving his presence?
I do.
And time is waived to the trial date?
Yes, it is.
All right, have a great day.
Thank you, Judge.
We have Norman Hooker, it's at 10, the state's going to.
Okay, let's do that then. Right here.
Yes.
All right, this is a matter of state of Ohio versus Norman Hooker, case number B2204290A. Mr. Hooker is present in the courtroom with his attorney, Mr. Arthur Souther. How did I pronounce
That's
it?
actually perfect.
That was, okay, great, and Mr. Nick Ramsey for the state of Ohio. This matter is on for jury trial. This is the second trial setting. The state requested a continuance last time until today because it's my understanding that the victim was in the hospital, in the Tennessee hospital, and the state did not proceed. What's the status today? Is it ready for trial?
It is not, Your Honor. The state is unable to go forward at this time. I will not be asking for a continuance. I would like to throw on the record the subpoenas in this case that were not sent today. I've been in constant contact with the attorney representing this individual in Tennessee. It became clear that he was never going to be able to come up here, and we were working all even up to last Friday to find a new individual that could testify, a property manager perhaps. They weren't successful in corruption. At this time, I'm not asking for continuance, but the victim was notified and there were no subpoenas issued for this particular case.
All right, thank you very much for putting that on the record. I think that sufficiently complies with Marcy's law. State's request, this matter is going to be dismissed for want of prosecution. And you are free to leave, Mr. All right.
Judge, if I could just briefly, I don't think that the state's going to object to this, but in the dismissal entry, his truck has been sitting in the impound lot. And just for the sake of clarity, if the court could maybe put a sentence in it at waiving the impound lot fees, which I think when the police came in said that they were not charging him. But I just want to make sure that when he takes the dismissal order to the Cincinnati Police Department impound lot, that they're not going to charge him for 4 or 5 months worth of impound fees. He knows he has to pay the tow truck fees. And I don't know if the court would consider just putting that in there, since it's that waiving that any impound lot fees. He's been unable to use the truck and
I don't know what the police department's procedure is with regard to that, you know. So why don't we do this? Does the state have any objection to doing that?
I would defer.
Yeah, all right, I'll do that. I'll put the sentence in there, Ms. Howard. It says, dismiss from warrant of prosecution and put a sentence that the vehicle impound lot fees are waived. Okay, all right,
thank you, Judge.
Thank you.
Thank you. I'll reach out.
I did, I texted them to you, I'm sorry. Okay.
All right, this is a matter of State of Ohio versus Chad Webb. Case number E. 22-01979. Mr. Webb is present in the courtroom with his attorney, Ms. Kelly Leggett, Mr. Nick Gramke for the State of Ohio. This matter is on today for plea, and I have been handed plea documents. Is this how your client wishes to proceed today, Ms. Leggett? All right, Mr. Webb, is that accurate?
Yes, sir.
All right. Sir, are you the Chad Webb named in this indictment?
Yes, ma'am.
How old are you?
43,
And how far did you go in school, Mr. Webb?
college.
So you're able to read and write the English language well?
Yes.
Mr. Webb, are you a U.S. citizen?
Yes.
Have you ever served in the military?
No.
I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize your attorney's signature here. Is this your signature above where it says defendant?
Yes, Your Honor.
This is an acknowledgement by you that you understand you have a constitutional right to have a trial, but when you sign this form, you're indicating to the court, I understand I have that right, but I am waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes.
Did you sign this form after consulting with your attorney about your constitutional right to a trial?
Yes.
Do you have any questions about this form?
No.
Do you have any questions about your constitutional right to a trial?
No.
I also have in my hand a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. Well, right up here it says agreed sentence plea. That tells me, as the court, that there's a recommendation between you and the state on what I should sentence you to. Is that your understanding of what's happening?
Yes, Your Honor.
All right. On the 3rd page, there are signatures. I recognize Mr. Gramke's signature here, your attorney Ms. Leggett's signature here, but up here where it says signature of defendant, is that your signature, sir?
It is.
All right. Mr. Prosecutor, would you please put on the record the party's expectations regarding this plea?
Yes, Your Honor. Your Honor, this is a 2-count indictment. Count 1, aggravated possession of drugs and felony in the 2nd degree. Count 2 is aggravated possession of drugs and felony in the 5th degree. The state is expecting a guilty plea to count 1 that will be reduced to an aggravated possession of drugs and felony in the 3rd degree. Your Honor, for that guilty plea, we would in exchange dismiss count 2.
All right, Ms. Leggett, is that accurate?
Yes, Judge, that's our understanding.
Is that your understanding today, Mr. Webb?
Yes.
All right. Mr. Webb, are you under the influence of any medications, alcohol, or drugs today?
I take for mental or depression.
All right. Does that medication regimen in any way affect your ability to understand what's going on today?
Not
All right. Has it affected your ability to be able to communicate effectively with your attorney?
No.
Okay. If at any time you feel, and I know you may be a little nervous today, but at any time you feel that you don't understand or didn't quite get something I said, just stop me or tell your lawyer, okay? All right. Do you now, or have you ever suffered with any other mental health difficulties other than depression?
No.
All right. Are you presently under any type of probation or community control supervision in this or any other state?
No.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No.
Has anyone promised you anything at all other than the dismissal of count 2 if you enter into this plea of guilty today?
No.
Okay, do you understand what I asked?
Yeah.
Okay. Are you making this plea of your own free will?
Yes.
Now, the state has indicated that there has been a negotiated agreement that of this 2-count indictment, count 1, you would be entering a guilty plea, but it's going to be reduced from a felony of the 2nd degree to a felony of the 3rd degree. Same offense, but just lowered the offense level. Do you understand?
Yes.
And that in exchange for your guilty plea on that reduced charge, that you would, the state is asking the court to dismiss count 2 of the indictment. Is that what you talked with Ms. Leggett about before this hearing today?
Yes.
Did you have an opportunity to review this 3-page plea form with your attorney before this hearing today?
Yes.
Do you understand what it says?
Yes.
Do you have any questions about it?
No.
Did Ms. Leggett answer all of your questions about it?
She did.
Now, do you understand that while the state, you and the state have presented to the court a sentencing recommendation that you serve 2 years in the Ohio Department of Corrections to run concurrently with your Warren County sentence, do you understand that I don't have to accept that?
I did.
Now, I'm not indicating in any way that I'm not going to at this point, but I need you to understand that I'm not obligated to accept that recommendation.
I understand.
All right. Knowing that I'm not obligated to accept the recommendation, do you still wish to proceed?
I did.
Mr. Webb, do you feel like you've had enough time to sufficiently consult with Ms. Leggett about your entire case before this hearing today?
Yes.
And has your lawyer answered all of your questions to your satisfaction?
Very much.
Have you had an opportunity to review and or discuss the evidence that the state has against you with your attorney?
Yes.
Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge?
To my knowledge, everything has been provided, Your Honor.
All right. You acknowledge receipt of same, Ms. Leggett?
Yes, Judge.
Mr. Webb, are you satisfied with your attorney, Ms. Leggett?
Yes.
I'm sorry. Now, do you understand this charge that's been amended? Aggravated possession of drugs in count 1, a felony of the 3rd degree.
Yes.
And do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in that count of the indictment?
Yes.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes.
Now, this being a felony of the 3rd degree, do you understand that you are facing up to 36 months in prison and up to a maximum fine of $10,000?
I did.
Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years?
Yes.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand?
I did.
Are you on post-release control right now?
No.
Well, if you are on post-release control and you commit a new felony offense while on post-release control, In addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains on your post-release control time, or whichever is greater. Do you understand?
I did.
Do you have any questions so far?
No, ma'am.
If I impose court costs and you fail to pay your court costs, I could order you to do community service. Do you understand that?
I do.
Now, Mr. Webb, when you plead guilty, you give up some very important constitutional rights, and I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a right to have witnesses subpoenaed to come to court and testify for you?
Yes.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes.
And finally, do you understand that at trial, you cannot be forced to testify against yourself?
Yes.
Do you understand each of these rights as I explained them?
I do.
Do you have any questions whatsoever about your constitutional rights?
No.
Do you have any questions whatsoever about anything we've discussed today?
No, everything's been clear.
Knowing everything the court has discussed with you, do you still wish to enter a guilty plea to count 1, aggravated possession of drugs amended to a felony of the 3rd degree?
I do.
All right, counsel, is there anything further before I accept the plea?
No.
May I hear a statement of facts?
Yes, Your Honor. Chad A. Webb, the defendant, on or about April 23rd, 2022, in Hamilton County, state of Ohio, knowingly obtained, possessed, or used a Schedule II controlled substance. This was methamphetamine in an amount that equaled or exceeded 5 times the bulk amount, or was less than 50 times the bulk amount. Your Honor, this has been reduced to a felony of the 3rd degree. It was a traffic stop. The drugs were found in the vehicle.
All right. Mr. Webb, did you hear what the prosecutor said you did?
Yes.
Is it true?
It's true.
What is your plea to count 1, aggravated possession of drugs, a felony of the 3rd degree?
Guilty, Your Honor.
Let the record reflect that Mr. Chad Webb was in court with his lawyer, Ms. Kelly Leggett, and that Mr. Webb was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Chad Webb understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts his guilty plea and finds Chad Webb guilty as to count 1, aggravated possession of drugs, reduced to a felony of the 3rd degree in violation of revised code 2925.11 subsection A. Count 2 of the indictment is dismissed at the state's request. Counsel, is there any reason why sentence should not be entered today?
No, no.
You waiving the PSI?
Yes.
All right. What would you like to say on behalf of Mr. Webb?
Judge, Mr. Webb is ready to get this behind him. He was sentenced already in Warren County to 2 years. We're asking the court to follow that recommendation. He's just ready to get this behind him and get back to prison and get his time served and move on with this.
All right. Thank you. State?
Your Honor, resents for the recommendation.
All right. Thank you very much. Mr. Webb, is there anything you want to say before I pass sentence today?
I'd just like to thank the prosecution for working with me and thank the state for supplying this lawyer to represent me. And like she said, I've already enrolled in some programs where I'm at Madison Correctional Institution, and I was in a bad way when this happened, and I'm trying to get all that back together.
All
Take
right.
care of my kids and myself.
All right. Well, I am glad to know that you have already enrolled in some classes in the institution and on your way to restoring yourself to being a productive citizen. And so I am going to follow the recommendation, the sentencing recommendation of the parties. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've also considered the joint recommendation of the parties. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I also consider the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, Mr. Webb, I hereby sentence you to a term of 24 months in the Ohio Department of Corrections with time for 106 days jail credit. The sentence shall run concurrently to your sentence served in Warren County. Are you serving under two numbers in Warren County?
I don't believe so.
Okay, can we? I believe the case number is 2022-CR039154, but you also have 2022-CR039323. I don't know if that's a concurrent.
There was two, I'm sorry, I forgot they had to give me two because of the failure to comply. They couldn't
All right.
be concurrent with it or whatever.
All right, so the sentence will be run concurrent to the Warren County sentence. Because you have been in prison, you are serving a prison sentence right now. Costs and fines will be remitted. Upon your release from prison, you may be on post-release control for up to 2 years on this sentence. Do you understand?
Yes.
All right. Counsel, is there anything else? Dave?
No, Your Honor.
All right. You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand?
I do.
I wish you well.
Thank you. Thank you.
All right. All right, can I have all the attorneys on Gerontanis et al. Versus City of Reading, Ohio et al. Approach, please. Case number A 1805317.
Sorry, I don't really have the law, but you're gonna tell us.
Oh, okay. If they're not, then I'll just wait. All right, is Mr. Fox here, Ms. Glazer?
I'm not sure. I don't see why.
Okay, thank you. Yes. All right, Mr. Graham, can you be anything else ready yet?
We do not.
Okay.
Stevens is here on the trial.
Yes.
That's the trial.
All right. Is everybody here? Okay, perfect. All right. All right.
Okay.
I'm waving at you. I'm waving at you. Yes. He goes to church. He goes to the same church. His wife is like a minister's Mr. Stevens, you want to talk?
You want to talk about your mouth?
Sidebar.
We're on.
Yes. Thank you, sir. Thank you. Thank you. There's a lot of this. Whatever you see in there.
All right, this is a matter of, Nordentonis et al. Versus City of Ohio, Reading, Ohio et al. Nancy Council. Can council please approach this right there, son. Yeah, thank you. All right, so, can I have your appearances for the record?
For the plaintiffs, James Patrick and Greg Hall.
Thank you.
And for defendant Lone Star, Robert Panowski and Michael Feldman.
All right, thank you very much. So, this matter has been pending quite some time. We definitely want to begin this trial. I will tell you that I have a criminal matter also set today that I am told by the parties is actually going. But what I did so that this will not be a delay is we have a backup visiting judge awaiting to try this case in 566. So that's what's getting ready to happen. You're gonna have the bailiff for 566 come down. The judge has been briefed and prepared, and I've given him all of my trial work, given it to the judge. So it will be Judge Sunderman, and he will try this case, because it's my understanding that you're expecting about 2 weeks for this trial. All right. And I really wanted to try this case. But I have another one that has to go. So, all right. But I did want to address two things with you. The first thing is we had such difficulty with getting interpreter for the Greek interpreters, but we have 2 Greek interpreters, so that's great. The thing is, the parties agreed to allow the interpreters early access to the medical records so that they can get familiar with the terminology. And to my knowledge from the language department, as of Friday, that has not been done. So why not?
Your Honor, if I may speak to that, that is not accurate. We did get a message from the language department. We were waiting to hear back from them, and then I believe it was on Thursday, we followed up when we had our paralegal drop a Dropbox link to all those documents to, it's called JS Interpreters Service.
When was that? Because
Thursday, and then again Friday, because somebody then notified us on Friday by email that they somehow did not receive it. So we once again sent it out on Friday.
okay, so it must have been sent again on Friday after I was notified they hadn't received it. So hopefully they have it now. I'm not sure, but that's that was the agreement. That's what I expected, given that there is going to be jury selection probably most of today, maybe even into tomorrow. Hopefully the interpreters can make use of the early access to the medical records. The other thing is, Matt, can I see you for a second? So the other matter that I wanted to address was the Zoom testimony. And I know, and I appreciate council's diligence in trying to get me to make a decision about that, but because we were tentative whether or not I would be trying the case or a visiting judge would be trying the case, I reserved not ruling on that because I don't want to tie the hands of Judge Sunderman, who is actually going to try this case. I will tell you right now, I don't know what he's going to do. I'm going to let him make that decision, but let me just give you a heads up. He's probably going to say no. All right? I know what I said to you, but that was when I was going to try the case. But now that I need this case to go today, and the visiting judge is going to be hearing it, I'm not going to tie his hands. So it's going to be up to Judge Sunderman. So I'm not going to say no, but I'm just giving you a heads up that it's likely to be a no from Judge Sunderman. And that's why I waited to make the decision, because if my criminal matter resolved, I would be trying the case. I would want to do. So that was the delay. Do you have any questions for me? I'm about to send you up to the room 566, and this is Matt. He is the bailiff for Judge Sunderman, and so he will take good care of you. And all of your exhibits that you delivered here have already been taken upstairs to 566, and the judge is just ready for you. Okay? Is there anything, sir?
Hi, Your Honor, on behalf of the plaintiffs, in light of this development that we didn't foresee, I would like to inform my clients, and I don't know if I will end up making a record or not. I just wanted to make it aware of that, because I do need to confer with them, bring them up to speed on what's going on with that news in their case.
Sure, I understand that.
And likewise.
Yes, and I totally understand that. So, you know, this is a situation where the case has been pending for what, 4 years? And, you know, due to no one's fault, obviously, but I'm sure that the parties, not only the Jared Thomas family, but also Lone Star, want this matter to be resolved. And the only way I could guarantee that it would be resolved as scheduled was to get a visiting judge. And so I just did not want you to come here, which happens too often, to come here and a criminal matter for someone who's incarcerated takes precedent and then it has to be delayed again. So it is happening. It's happening today. And so you can go ahead and go with Matt, and then you can revisit the issue of the Zoom testimony, the live stream testimony with Judge Sunderman. Okay? All right. Thank you very much.
Hi, how are you?
This is the matter of State of Ohio versus William Roden. This is Mr. Roden. This is Mr. Huber. Okay, that's not one. All right, Mr. Huber. All right, this is the matter of State of Ohio versus Thomas Huber, case number B220560. Mr. Huber is present in the courtroom with his attorney, Ms. Madison Meredith, and Mr. Nick Gramke for the State of Ohio. This matter is set for plea today. I have plea documents that have been provided to the court. Is this how your client wishes to proceed today, Ms. Meredith? Yes, sir. All right, is that true, Mr. Huber? All right. Are you the Thomas Huber named in this indictment? Mr. Huber, how old are you? 38? How far did you go in school? All right, so you're able to read and write the English language well?
Yes.
Are you a U.S. citizen?
Yes.
Have you ever served in the military? Mr. Huber, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. At the bottom, I recognize your attorney's signature. Is this your signature here where it says defendant? This is an acknowledgement by you that you understand that you have a constitutional right to have a trial. But when you sign this form, you're indicating to the court, I understand that, but I'm waiving my constitutional right. Is that your understanding of what you were doing when you signed this form? Did you sign this form after consulting with your attorney about your constitutional right to a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to a trial? I also have in my hand a 3-page document entitled Entry Withdrawing a Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize the prosecutor's signature here, your attorney's signature here, but up here, sir, is this your signature where it says signature of defendant? Mr. Prosecutor, would you please outline the party's expectation regarding this plea?
Yes, Your Honor, this is a 4-count indictment. The state is expecting guilty plea as charged to count 1, having weapons while under disability, a felony of the 3rd degree. The state is expecting a guilty plea to count 2, possession of cocaine, a felony of the 5th degree. For those 2 guilty pleas, the state would dismiss count 3 and 4, Your Honor.
All right, is that accurate, Ms. Meredith?
That is, Your Honor.
Is that your understanding today, Mr. Huber?
Yes, Honor.
All right. Sir, are you under the influence of any medications, alcohol, or drugs today? Do you now, or have you ever had to manage any type of mental health difficulties?
Yeah, I see it's fun.
Okay, can you tell me about that?
Just like, I guess it's like bipolar issues or PTSD. I'm talking like.
Okay,
I don't know what to call it.
all right. Were you prescribed medication to manage those
Yeah.
conditions?
Yeah.
Are you still taking them
Yeah.
as prescribed?
Yeah.
All right, did you take them this morning? Does the taking of those medications in any way affect your ability to understand what's going on today?
No, no.
Do they affect in any way your ability to have good communication with your lawyer?
No.
All right. If any time you don't understand something I'm saying or just a little confusing to you, just stop me.
Okay.
All right, and I'll rephrase and you can talk to your lawyer, okay?
Okay.
All right. Are you presently under any type of probation or community control supervision in this or any other state? Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all if you enter into this plea of guilty today, other than the dismissal of counts 3 and 4? Are you making this plea of your own free will? Now, the state has indicated, Mr. Huber, that you would enter a guilty plea as charged to count 1, having weapons while under disability, a felony of the 3rd degree, and count 2, possession of cocaine, a felony of the 5th degree. Is that what you talked with your lawyer about before this hearing today? Did you have an opportunity to review this 3-page plea form with your attorney?
Yes, ma'am.
Do you understand what it says?
Yes.
Did she answer all your questions about it?
Yes.
Do you have any questions about it now? Mr. Huber, do you believe you've had enough time to sufficiently consult with Ms. Meredith about your entire case before this hearing today? Has your lawyer answered all of your questions to your satisfaction? Have you had an opportunity to review and or discuss the evidence that the state has against you with Ms. Meredith before this hearing today? Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge?
To my knowledge, the state has provided everything, Your Honor.
Ms. Meredith, do you acknowledge receipt of same?
Your Honor, I'm satisfied, but I will say on the court date for January 25th, the previous prosecutor had indicated that there might be more discovery coming, but nobody can, but she didn't know for sure. I had discussed that with Mr. Huber beforehand. He wanted to plead early. He did not want to wait for discovery, so we're satisfied.
All right. I also have that in my notes, that there may be more renew reports outstanding.
Yes.
Mr. Huber, your attorney said that given that situation, that you did not want to wait to review any more discovery, if there were any. Is that true? And that you wanted to resolve your case today. Is that true? All right. Mr. Huber, are you satisfied with your lawyer, Ms. Meredith? Now, do you understand the charges that you'd be pleading guilty to today, counts 1 and 2? Having weapons while under disability, a felony of the 3rd degree. Do you understand that charge? Do you understand count 2, possession of cocaine, a felony of the 5th degree? Do you understand that if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in those 2 counts of the indictment? You understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately. Now, count 1 being a felony of the 3rd degree, do you understand you're facing up to 36 months in prison and up to a maximum fine of $10,000? Do you understand that as to count 2, possession of cocaine is a felony of the 5th degree, that you're facing up to 12 months in prison and up to a maximum fine of $2,500? You understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years thereafter. Do you understand? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that? Are you on post-release control? Well, if you are on post-release control, and you commit a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term, or whatever time remains on your post-release control time, or whichever is greater. Do you understand that?
Yes.
Since these are felonies of the 3rd degree and 5th degree, community control is a possibility, probation. Do you understand that I could place you on community control for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions of community control, then you'd be brought back before me for a more restrictive sanction, which could include a whole host of things. But the most severe penalty could be up to 36 months in prison on count 1 and up to 12 months in prison on count 2. Do you understand that? Do you have any questions so far?
No.
Also, if I impose court costs and you fail to pay those court costs, Mr. Huber, I could order you to do community service instead. Do you understand? Now, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to a trial, either to the court or to a jury of 12 persons? You understand?
Yeah.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, ma'am.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself? Do you understand each of these rights as I've explained them? Do you have any questions about your constitutional rights?
No.
Do you have any questions whatsoever about anything we've discussed today? You understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights. Knowing everything the court has discussed with you today, Mr. Huber, do you still wish to enter a guilty plea as charged to count 1 and 2 of the indictment? Counsel, is there anything further before I accept the pleas? There. And here's a statement of facts.
Yes, Your Honor. Thomas Huber, the defendant, are about November 28th, 2022 in Hamilton County, state of Ohio, did knowingly acquire, had, carried, or used a firearm, and at the time the defendant had been convicted of a felony of offensive violence. This was a burglary in Claremont County in 2004, and at the time of this indictment, the defendant had not been relieved from such disability under operational law or legal process in violation of 2923.1382 of the Code C. Second count, Your Honor, Thomas Huber, on or about November 28th, 2022, in Hamilton County, State of Ohio, did knowingly obtain, possess, or use a Schedule II controlled substance. This was cocaine in an amount that was less than 5 grams, in violation of 2925.11A, Your Honor. This was a altercation. Officers were called to the scene. They detained the suspect, the individual. I don't believe the altercation was physical or seriously physical. He was detained, was found on, he was quite cooperative, and told him where the gun was that it was his.
All right, thank you very much. Mr. Huber, anything on the minutes?
Nothing on the text, Your Honor.
Mr. Huber, did you hear what the prosecutor said you did?
Yes.
Is it all true?
Yes.
What is your plea to count 1, having weapons while under disability and felony of the 3rd degree?
Yes.
What is your plea to count 2, possession of cocaine and felony of the 5th degree?
Yes.
Let the record reflect that Mr. Thomas Huber was in court with his lawyer, Ms. Madison Meredith, and that Mr. Huber was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Huber understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding them to be voluntary, the court accepts the guilty pleas and finds Mr. Thomas Huber guilty as to count 1, having weapons while under disability, a felony of the 3rd degree, in violation of revised code 2923.13 subsection A2, and finding his guilty plea to count 2 to be voluntary, the court accepts the guilty plea and finds Thomas Huber guilty as to count 2, possession of cocaine, a felony of the 5th degree, in violation of revised code 2925.11 subsection A. Counts 3 and 4 are dismissed at the state's request. Is there any reason, counsel, why the sentence should not be interested?
No, Your Honor, we're ready to proceed.
All right. Are you waiving PSI?
Yeah.
All right. Would you like to say on behalf of Mr. Huber?
Your Honor, as the prosecutor pointed out, he was very honest with the officers. He told them that there was a weapon in the house, told them where it was, indicated it was his, even went to explain how he had purchased that firearm. He was very open and honest with them when he had the interaction. Since being in the Justice Center, he's taken advantage of a lot of their programs. He's on his mental health medication there. He also started the MAP program, which is the treatment program. I actually had that confirmed, I think last time or the time before that I visited him. He was in his medication. I saw a nurse, asked her to confirm. She said he was in that program, which means that he gets Suboxone. So he's been on Suboxone since getting into that program. He's been on Suboxone shortly after he arrived at the Justice Center when he started it. So that was something that he immediately jumped headfirst into. He knew he wanted to get into that program and start working on those things, which I think is pretty commendable. He indicates that he has not been on probation since 2004. I think that was related to the charge that has him under disability. He has not been given that opportunity since then. This matter, while it was related to a situation that the police come out to where he wasn't driving, he wasn't out any place that had him stopped by officers. They came to his home, and that's what he was honest about what was in his pocket and about that he had the firearm. He's working on getting his license back. He's pretty close to having that. I'm sorry, he did get that back. He got that back before getting picked up on this, Your Honor. His family lives out in Claremont County. He has one pending matter out in Claremont County. It's a child support case. They have a folder for him, actually, but he's expecting to be placed on probation to that, and because he's got a job lined up, ready to go when he is able to get out. He is a subcontractor for Lowe's. Him and his father have a business where they do it together when they lay carpet down. He also has some family that are having some health concerns that he's pretty worried about, wanting to be able to help support them while they're going through a pretty difficult time. He's wanting to address this case. He wants to address the case out in Claremont County, as we stated before. It may have come to light that there was more discovery missing, but he didn't care about that. He wanted to go ahead and plead guilty. Like I said, he was already honest about it to begin with the officers, and he wanted to take care of this and then move on to take care of this case in Claremont County. Given that he has really tried to use what programs have been available to him in the Justice Center, and he really wanted to take care of these matters and take responsibility, I'm asking the court to give him an opportunity on probation. I know he's got some records or some cases on his record, but I think he's ready. He knows he needs to get these things addressed. As I stated, he was really quick to join the MAP program in the Justice Center, which I think speaks well to his intentions. Your Honor.
All right, thank you very much. State.
Consider referring.
All right, Mr. Huber, anything you want to say before I pass sentence?
No, just everything that she said, to be the same, like I said, I don't want to waste your time anymore, people. We got other stuff to do, so. I appreciate it.
Your Honor, I did forget to mention, I think he's been in for about 89 days, if I did the time right.
Yeah, I have 90 as of today.
Okay.
All right, the court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the recidivism factors and seriousness factors as set forth in revised code 2929.12. Accordingly, Mr. Huber, I hereby sentence you to a term of 2 years of community control, intensive supervision. That's probation, where you will be drug tested and you have to dot your I's and cross your T's. You understand?
Yeah.
All right. You will pay court costs, but there will be no fine. If you violate the terms of community control, I will sentence you to a term of up to 36 months on count 1 in the Ohio Department of Corrections and up to 12 months on count 2 in the Ohio Department of Corrections. Do you understand? All right. Anything else to have for the council?
Your Honor, I would just note, for probation purposes, that he will not be able to report until
Yes.
Claremont County is over.
We will make that note.
Wonderful.
And you are to report as soon as you are finished with, is it
Claremont County.
Claremont County, all right? Immediately. All right, because failure to report immediately will be a violation, okay? All right, anything from the state? All right, anything else?
Nothing, Your Honor.
All right, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand that, Mr. Huber?
Yeah, thank you.
All right, I wish you well.
Thank you.
Your Honor.
All right, Mr. Stevens?
We approach, Your Honor.
Sure. All right, this is the matter of State of Ohio versus Kenneth Ty, case number B22038284 and B2103010. Mr. Ty is present in the courtroom with his attorney, Mr. Philip Stevens, and Mr. Nick Ramke for the State of Ohio. This matter is set for trial today. It's my understanding that another trial is going to proceed. It's older, and the individual in that case is incarcerated. Mr. Ty is on bond. So I will have to continue this matter for a status, so we can pick a new trial date.
Yes, Your Honor.
Let's get a status in the voucher. And it's my understanding the state is ready to proceed today,
Yes, Your Honor.
and is the defense ready to proceed today?
Yes, Your Honor. Some of the pretrial motions have not really been addressed. Yes, we were prepared.
All right. Put it on the back hall. Okay. This will be continued at on the court's own motion, so it won't go against either side. And I will ask Mr. On behalf of Mr. Ty, is time waived?
Yes, Your Honor.
Okay. Martha?
Excuse me, Your Honor. Mr. Ty now explains to me that he does not want his time waived.
You got a question? You want to ask your lawyer the question first, or you want to ask me? No? You don't? Okay. Time is not waived, so stay tuned because your trial may go later this week. Yeah, until later time. Yes. So what I may have to do is have it, by a visiting judge, tried by a visiting judge, because he doesn't wait time, and I can only try so many cases at a time. No. No, I don't want you to feel not even the slightest pressure to waive any time. You want to talk to your lawyer real quick? March 6th, we'll back it up with the visiting judge. The trial will be continued to March 6th. We'll have a visiting judge here, the case will be tried in front of the visiting judge.
Just in full transparency, Your Honor, I do have a trial scheduled that day. It is a murder trial, scheduled for Judge Marsh's room. It's 3 years old.
Okay.
And obviously the client is incarcerated since it's a murder trial. It may not go. I just wanted the court to know I may be requesting a continuance
Yes.
on that day if that
Sure.
trial proceeds.
I understand.
Thank you.
I fully understand that. So we'll go ahead and set this for March 6th. Or do you want us to set it for another day? Because it sounds
Yeah,
like
Your Honor.
getting ready for it.
I'll be here and be prepared on March 6th, Your Honor, provided the other trial does not proceed.
All right, trial March 6th, Mr. Ty. I will back this up with the visiting judge because I already know I have a trial on March 6th. So we'll see you on March 6th. Okay?
Thank you, Your Honor.
All right, Mr. Adams?
Yes, Judge.
You want your client brought down?
No.
You and Mr. Costa?
Wait, Mr. President.
All right, we'll get your client's presence. These are the matters of State of Ohio versus Trayvon Epperson, case number B22-05005A. Joseph Watkins, no, yeah, Joseph Watkins, the B defendant, and Jaquan Thomas, the C defendant. Mr. Epperson is represented by Mr. Adams, who's present. Mr. Watkins is represented by Mr. Costin, who's present. And Mr. Thomas is represented by Mr. Neff, who is present. Are your clients, anybody's clients present other than Mr. Epperson is in custody, and so is Mr. Watkins. Mr. Neff, is your client here?
Judge, I haven't seen him this morning. I haven't looked in the hallway recently. I can't tell the court. I believe he's hired private counsel who's standing next to me, so he may not be contacting me directly.
Okay, is he here?
I haven't seen him, Judge. I did email him a few minutes ago. To see where he was.
You have not seen him?
I haven't seen him this morning.
Okay. Well, this was set for trial today. And, Mr. Aaronstein, you've been retained?
Yes, Judge. You may know, I was out of the country for 2.5 weeks, and I met with Mr. Thomas right before I left. And I indicated that if you're going to hire me, let me know so I can let the prosecution know ahead of time. And of course, while I was out of the country, they came in and they retained me. I found out Friday when I returned to the office. I called the prosecutor, told me that I had been retained. So I'm here today, making my first appearance on this matter. I also understand Mr. Costin has a conflict of interest with the case as well. So that could be an issue that the court would like to address as well.
All right, Mr. Costin,
Yes, sir.
what do you want to say?
Well, I had two issues. I initially filed a motion to continue the case because there's some discovery still outstanding. And then on Monday of last week, the holiday, I was at the Justice Center reviewing the discovery with my client. And after about 2.5 hours of watching video, I had scrolled through about 90 pages of discovery and discovered a juvenile court entry in 2019 where I had represented Mr. Adams. And I believe that Mr. Adams' client and my client are in a position of opposition at the moment, so that's going to require me to withdraw.
Okay. All right, State, anything you want, well, Mr. Adams, anything?
Just we're in active plea negotiations at this point, Your Honor, and I do have a signed speedy trial waiver in my file on behalf of my client.
All right,
So we would be seeking a continuance as well while this sort of fleshes out.
okay. All right, well, let's start with Mr. Costin's client, that is Mr. Watkins. So, Mr. Watkins, you were appointed, right, Mr. Costin?
That's correct. And I filed a motion to withdraw and emailed it to Ms. Howard and prosecution. And I advised my client Friday of the issue, so he's aware of it as well.
All right, so the motion to withdraw for good cause is granted. And we will have the PD's office appoint someone for Mr. Watkins. And then obviously the motion to continue to file, I'm going to grant that for the record as well. Mr. Aaronstein, you being retained, I will substitute counsel, Mr. Neff, for Mr. Aaronstein and continue the matter. But I'm concerned that your client is not present.
So I just,
So,
like, check out the whole.
yeah, check out the home because I might do a warrant.
You'll be able to.
May I approach it? Chief Quantas,
Just Howard, the,
Sure, thank you very much for that.
Jaquan Thomas?
The detectives haven't seen him and no one place.
The state had to say about Mr. Thomas.
Your Honor, I guess I'll answer our cases at this point. I kind of defer to how his payments. Seems odd that he walk in, turns out to pay money, and then not show up for his case.
That seems strange.
It seems strange, but I've seen strangers. For sure.
This is our life.
I know, that's what I'm saying. You can't put anything, you know, we're in the land of the strange, so.
Do what you feel is appropriate, Judge. I'll reach out to him if I find him over in the direction.
Okay, so, capias to issue, 50,000 straight secured. I will, consider bond, bring him in, turn him in. He just needs to know, he needs to be in court. I haven't seen him since the case started, so, he needs to be here.
I understand.
Set for trial. That's Mr. Thomas. So, Mr. Neff, you will be permitted to withdraw. You're withdrawn. Mr. Costin, you're withdrawn. And then Mr. Adams, I guess what we need to do is set a new trial date. We can't do that yet because we have a new counsel.
So my suggestion would be a status,
Yeah.
a fairly quick status.
That's what we'll do. That would be good. So let's set a status as how we can get new counsel on board, and court date, trial date.
How about Wednesday, March 8th?
That's fine with me.
Okay, that good?
Yeah. Yeah, that's fine.
All right, so we'll set it for a status, March 8th at 9 a.m. And Mr. Thomas has a capias, but that's the date we're gonna set, and then, Mr. Watkins, the same thing, and then we'll, go ahead and, set some new dates when we, once we get all council present, okay? Thank you very much.
Thank you.
Do you want us to sign it in a second?
Time wait for Mr.
Epperson.
Epperson, thank you.
Yes, Judge, thank you.
And, yeah, okay, thank you. All right, where's Ms. Polston? Mr. Jackson, you've been sitting here waiting patiently. I didn't think you had a case today. He does? You do?
I don't know.
No, okay. Okay. I did see Mr. File.
Yes.
There you are.
The co-defendant case with Darren Nye, Your Honor.
Yeah.
I think
know
he
he's
may
in
have,
here.
he may have been called to do a plea on lockout.
Oh,
Judge gives his room. I just have a bond pending motion,
I know.
which is totally irrelevant, does not affect Mr. Nye's proceedings. We talked about that this morning. May continue next month on some days.
Well, let's go ahead and bring him down. You're fine. Mr. Roden. Yeah,
RHOE.
and then we're gonna start this trial.
That's fine, Judge.
Start. Oh, my God. Mr. Fox, Ms. Glazer, have you resolved the closed issue?
We believe that we have, Your Honor. We were able to acquire the new clothing from the public defender's office, and that has been checked in, and I spoke with the property manager, who is, it's my understanding they're taking him back, getting him changed out, and sending him back.
Okay, perfect. So by the time we call him, he should be ready.
Hopefully, you're ready.
That's perfect.
So we did address that and took care of it.
Okay, I'm really planning on probably about 5 to 10 minutes. All right, we are, getting ready to rock and roll.
Hi, Christina. I think I met you. Good to see you.
While I wait for Mr. Robin, I would like to talk to the lawyers on Glenn. If that's, you all are here and ready.
Yes, Judge.
All right.
I'm sorry. Yes, thank you. I think we worked it out, because there's not a whole lot in this one, so. Are we supposed to go back there with her?
No, she's not.
Okay. Well, I was just back. Yeah. All right. So.
All right, so I want to talk to you guys, before we bring your client down and panel and all that, which will be happening in just about within 15 minutes. I think, Ms. Holston, have you had a trial with me before?
I don't think so.
I don't think so.
I've had an awful lot set, Judge.
Yeah, you had a lot of evidentiary hearings, but I don't think we had a trial together. And, Mr. Fox, Ms. Glazer, have we had a trial? I don't think we've had one.
I had plenty of juvenile trials with you.
That's true, that's right, okay.
But no
Well,
jury.
it's the same.
No jury.
It's the same. So, I want a clean trial. I want a streamlined trial, evidence to the extent that you can. I'm not gonna tell you how to do your case, I wouldn't dare do that, but, I don't want any, cross evidence that shouldn't be. Let me ask the question. Are we proceeding today on counts 1, 2, and 3 only?
Yes, sure. We have, so on case B21-02474, we have executed plea forms on counts 1 and 2, which are the firearms charges on that case.
Okay.
On the B21-03303, we have a jury waiver as to counts 4 and 5 only, and we have executed plea forms on counts 4 and 5, which are the weapon, or carrying a concealed weapon and improper handling.
All right. See, that's what I'm talking about, streamlining. That's great. So we will have a jury trial just on counts 1, 2, and 3 of case B21-03303, which are count 1 murder, count 2 murder, and count 3 endangering children. I do know there are 2 motions in limine on behalf of the defense, and definitely want to talk about that.
Judge, I think we've worked out a fair amount of that actually through trial.
Excellent.
So.
Let's talk about the motion in limine regarding the evidence as to I think it was firearm counts 3 and 4.
I have no intent, as Mr. Glenn has pled to the firearm at this point, or has tendered plea forms to the court, if he's pleading to those, I have no intention of offering evidence that a firearm was found in his possession.
All right, well, that's good. I will tell you that even if without the plea, I would have granted it.
Okay.
But so since you all have streamlined it and the state is making a representation that you don't intend to even present it, then I guess I can deny as moot. Right?
I think so.
All right. I just wanted to let you know I was gonna grant it anyway. Deny as moot. And then, with regard to the motion in limine to exclude evidence at trial, there are 3, I'm gonna characterize them as statements or recordings. I'd like to take them one at a time. So, defense, do you want to talk about the recorded phone call at the Hamilton County Justice Center from Mr. Glenn to an unidentified friend?
Just 1 second, Your Honor. Your Honor, we've made a courtesy copy of the jail calls on a zip drive for the court, if the court wanted to hear the content of those calls.
Well, yes, I can do that, but I do want to just kind of get an outline, the summary of your argument. So, there's a recorded phone call from the defendant at the Justice Center to an unidentified third person. And they saying what? What's the conversation?
So, Your Honor, that's why it may be helpful for the court to actually listen to one of those phone calls, because I believe the state and the defense have a different interpretation of the content of those calls. The first one that we brought to the court's attention is a phone call with who appears to be Mr. Glenn's mother. The second one appears to be a conversation with him and a friend, where he's then put on three-way with other people being heard in the background and greeting him and talking about things that are not relevant to the case. The conversation, and we just have those 2 jail calls here that we can admit as an exhibit if it's helpful to the court. But the initial call with his mother, she is doing the majority of the talking, and I know that in the jail call context, you can sometimes admit statements of others for purposes of adding context, and it's not necessarily hearsay, but she's controlling the conversation in the phone call, and she's making allegations about possibilities of injuries and causes of injuries to Mr. Walters, the child in this case, and Mr. Glenn is not engaging in conversation, but rather making simple statements like he's listening, yes,
So how would the state get that in anyway? The state, is this evidence the state would use in your case in chief?
Yes, Judge. Jail calls have, several of all the jail calls are admissible. They are the defendant's statements. And in this case, in the jail call with the defendant's mother, they are discussing an alternative and making up, frankly, an alternative theory on how the child got the injuries that led to Christopher Walters' death.
Is there an admission by the defendant?
Yes.
In this particular jail call?
Yes, Judge. They have the recorded call. I have also printed out a transcript of the call for the court. I think it might be helpful if the court listens and.
I understand all that. You guys already told me that. I'll do what I need to do. I want to know, is there an admission by the defendant to commission of this offense? Because I'm trying to figure out if this is even relevant. I get that jail calls are admissible, but it still has to be relevant evidence. You can't just bring in jail calls about him talking about a trip he took to Las Vegas last year because it's the defendant talking. It has to be relevant to this issue. So my question again is there an admission by the defendant on this jail call to his mother?
He is talking to his mother about how they're concocting a story about how this baby, who is deceased, was in a car accident with the mother instead of in Leandre Glenn's care the day the baby died.
And how does that help the state's case that he killed the baby?
Judge, I think if people are trying to concoct alternative stories about how these injuries may have happened, it shows that they have something to hide. It shows that they are trying to provide an alternative rather than this baby was in Leandre Glenn's care for the entire day that this happened. There are two doctors who are going to say that the injuries that happened to this baby happened that day. Leandre Glenn is trying to say, wait, no, they didn't. This baby was in a car accident with the mother. This isn't my fault. But this is after Mr. Glenn spoke with police twice. So I think it shows that he's trying to concoct a story. He's trying to provide an alternative when the reality is Mr. Glenn was the one with the baby.
And this evidence you would seek to introduce would come in only if the defendant testified?
No, Judge, it comes in my case in chief.
Through
someone from the jail who will come in to say that these jail calls are regularly kept business records for the Hamilton County Justice Center.
Okay. And the defense would say that there is no admission?
That's correct, Your Honor. I've not seen the transcript of the jail call, but we've listened to it. And we dispute, I believe that that's a mischaracterization that he makes an admission for this alternative theory. There is discussion by his mother of the child being involved in a prior car accident, but there's nothing to connect the car accident to that day. And it's not our theory of the case. We're not going to come in here and present a case that the child suffered injuries by way of a car accident. And so because most of the content is his mother speaking and talking about a matter that's not related and not relevant, we don't think it should come in.
All right. Well, I will certainly listen to it. And do you have the recording and the transcript? Thank you.
I sent it to you guys.
Yeah.
Do you want?
We got an email.
Yeah.
All right, let's move on to the recorded phone call of the Hamilton County Justice Center. Thank you. From Mr. Glenn to an unidentified friend.
And
I do not have that one transcribed, Judge. I provided that to Ms. Goldsmith, and she indicated that there were so many parts of that jail call that were unintelligible that she was not able to transcribe.
Okay. The state still seeks to introduce it?
Yes, Judge.
For what purpose?
Here we have immediately after Honesty Jones' baby Christopher died. Here we have Mr. Glenn talking to his friend about how he ran her off the road and caused her to have a car accident, and Mr. Glenn is laughing about it.
Okay, so let me understand. You said that Mr. Glenn is talking about running off the mother off the road?
Correct. His friend did.
Oh, his friend is talking to him, Mr.
Yes,
Glenn,
saying
about the friend running the mother
Correct.
off the road?
Correct.
And Mr. Glenn is laughing about it.
Correct.
And how is that probative of this issue we're hearing for?
I think it shows an absolute lack of remorse and utter contempt for the mother of Christopher.
All right, and how would you intend to get that in through a business record of the jail?
And Judge, I think it also shows that Mr. Glenn is intimidating her.
Intimidating who?
The mother of the deceased.
By this other friend running the person over, running her off the road?
Yes.
Is there any conversation that Mr. Glenn directed that person to do it?
No, I think it would be after the fact encouragement.
All right, state defense?
Judge, again, I think there's some disagreement about the actual content of the conversation itself. There does seem to be some sort of message about the fact that a friend of Mr. Glenn's ran into Ms. Jones at an intersection, but there's nothing to suggest malicious intent, nothing that Mr. Glenn says that indicates he had any awareness or directed it in any way. There's no threat to her, and this would have been after the fact. I think it casts him in a negative light. In addition to that, there's a lot of slang on the phone call with his friends and references to things, to affiliations the jury could say are gang related or other kind of street talk, which we think is highly prejudicial and does not go to the ultimate issue of whether or not he caused harm to this child.
All right, so with regard to the recorded phone call of the Hamilton County Justice Center from Mr. Glenn to an unidentified friend, with regard to this incident of running the victim's mother, who's also a victim, off the road after the fact, the court finds that the motion in limine is granted. It's not probative, it's highly prejudicial, and although I understand that there may be some statements made by Mr. Glenn, most of it appears to be hearsay, and so I am going to grant the motion in limine. That is out. Now let's talk about Mr. Glenn's statements to detectives in the second interview.
Judge, we have actually discussed both of Mr. Glenn's interviews. We made 2 interviews to detectives, and I think that we have agreed on what needs to be redacted from those.
Okay.
So I think that motion in limine is moot. I don't want to speak for the defense, but I guess I can.
Okay, is that accurate?
No. That's correct, Your Honor.
Oh, good. Okay, so we'll just deny as moot. That. So the only thing that we have left in the motion in limine is the Justice Center call with Mr. Glenn and his mother, and I have that, and I will be reviewing that, and then I will let you know about that, okay?
I wouldn't know, I don't know if you would wait till your client gets here, but there are some stipulations in this case, Judge.
Yeah, I'll wait till he gets here.
Okay.
That, I just want to deal with those evidentiary issues. Are there any more motions in limine at this time?
I believe that takes care of everything that we had filed.
Okay, and state, is there anything you have in addition? I know we're going to do the stipulations.
I think I would just say my remarks first.
Okay, all right. Yeah, right after. Yes, that's what I'm saying. Okay. All right. This is the matter of State of Ohio versus William Roden, case number B23000169B. Oh, Mr. Nye, you are here.
I am here.
And State of Ohio versus Nikki Dyson, who is the A defendant.
And I'll waive my client's presence for today's hearing, except for trial, Your Honor. We did not have any pending motions, though we have been in discussions about resolution.
All right, thank you very much. Where's Mr. Graham? He's here?
I can be Mr. Graham.
Oh, okay.
He was just sitting next to me, actually, so.
Oh, okay, he must have stepped out. All right, thank you, Ms. Wilson. All right, so we have a jury trial set April 17th. Are you on track for that? Do you have discovery?
We do not have some primary discovery in this case, and I spoke to Mr. Green about that. I believe that there's a video that the homeowners have turned over to law enforcement. And I think we have some paper discovery, but that's primarily the entire state's case to show from point A to point B from the alleged burglary to the arrest, I believe, Your Honor.
That is correct from our standpoint also, Your Honor.
All right, Mr. Gramke.
Yes, Your Honor, I just received a video, not just received, I do have it. I'm just working on how to get it uploaded and sent. We're also outstanding DWC on this. Photographs and paper discovery was provided.
All right. All right, so, looks like we need to go ahead and set another, let's set a pretrial, Ms. Howard, and then a final pretrial.
Judge, and I think that when this was originally set for a trial on the 17th of April, we were very hopeful in our discussions that this may be resolved as a result of the video. And because the 18th, I'm out of the country for 2.5 weeks, and everybody was aware of it when we set it on the 17th. We're hoping to resolve it. Mr. Grimke indicates that he's had some arsonist discussions with his victims, and that may not be able to go down the path that we were hoping.
Okay.
So we may need to move the jury trial date if Mr. Roden decides that's the path he wants to go, Your Honor.
All right, well, let's go ahead and set a pretrial, so we can get all the discovery to counsel and see where we are.
March 15th.
March 15th?
I'm not available that date if I don't have issues. I mean, if there's.
Well, let's see, let's just see.
I am scheduled to start a jury trial in front of Judge Haddad in Claremont County on the 13th, and we have a video deposition of a medical doctor this afternoon. So that still is in progress, and we had hearings on Friday, just last week, so that hearing is going that whole week.
I understand.
You're right. As far as this, I know just one more thing. It's just going to go out the records. I am working, I got the release, so that should be. Notice that.
Perfect, thank you.
Did you say the 13th was no good?
Yeah, for trial.
How about the 22nd?
That's fine, Your Honor.
And again, I'll be in Butler County that morning, but as long as we have the discovery, that should not be an issue. Rich will have the same issue. So if you want to set it without me, I'm perfectly fine with that. Could we do the 23rd? How's the 23rd?
I'm good that day too.
Twenty-third it is.
Thank you.
So March 23rd, we'll set this for a pretrial, and then we'll see where we are. Hopefully discovery will have by then. All right, now, there are no motions for Ms. Dyson, and trial is the time wait until the 17th of April.
I did not discuss that with my client, Your Honor. So I would be hesitant to waive it at this time.
All right.
I don't want to waive it and find out that it's an issue for her. When I
All right.
see her.
Judge, we'll waive on behalf of Mr. Roden. We've had that discussion.
All right, thank you. Now, let's wait. Yeah, because we don't know if the trial's on. All right, so, Mr. File, you filed a motion for, to reduce bond.
May I be excused?
Yes, thank you very much.
We did, Your Honor, and based on the facts set forth in that motion, nothing has changed since the motion has been filed. He's still sitting on a $300,000 straight E&D bond, of which he cannot make. That was originally, then it went down to $200,000. He can't make that. He's on juris. He would be on E&D. They would be able to track him. He wanted the court to be aware, set forth in the motion. He could post a $50,000 10% bond. He's fairly confident that that could be done. He is not objecting to EMD. He's not objecting to juris status or a stay away order, which I think are all in effect at this point. And he also has a place to live with his parents and his minor child. It's in Fairfield, Ohio, but that's where everybody would know where he is living. The incident occurred as alleged in Colerain Township, so that's a significant mileage difference. And he does have a job, he reasonably believes, with Bill Stein as a laborer in a factory in Hamilton, would still be available to him. So he is asking the court to take that into consideration, Your Honor.
All right, thank you very much. State?
Your Honor, we would strongly object to any modification of bond at this time. This was a burglary. The defendant was just released after moving 4 years for a very similar offense. The homeowner came home, was a pretty serious altercation occurred.
Inside the home?
Outside of the home. I don't exactly know when it started, but the individuals remained on the scene. So it's a very strong case for the state. The injuries and the fact that this is truly a random victim in this case, I would object.
Who stayed on the scene?
So what happened, the allegations are the two individuals, the defendant and the co-defendant, were inside the home after kicking the door empty home. Obviously, not a vacant home, but the homeowners came home, saw them in the home. There was a I don't know if it was inside or outside, but there was an altercation that ensued where the victims, and I believe the defendants were injured. There's a lot of blood, Your Honor. Some of the pictures of these victims are concerning to look at. I don't think that there's anything gravely serious as far as their injuries, but it was more than a verbal altercation.
I see. All right.
Judge, I don't want to get into the facts of the case, but I think that's why the video becomes important, because I believe that Mr. Roden and Ms. Tyson have indicated from the point that they were arrested in this case that they were not in the home when they were detained by the homeowners. The homeowners chased them, and the homeowners actually engaged in assaultive behavior with the two defendants in this case. So that we're trying to figure out what actually happened by looking at the video. We can't answer, I cannot answer those questions right now, but I think that that's consistent with what I have been told, and apparently there was some partial video on the television news related to that as well.
All right, thank you very much. Motion to reduce the bond is denied. It will remain at 200,000 straight and EMU. And so we will come back on the 23rd of March at 9 a.m. for a pre-trial.
Okay.
All right,
Thank you, Your
very
Honor.
much.
Thank you.
No, I'm being serious. Like, I'll leave if you want. No.
Mr. Glenn is on his way down. I can go and get the pool now, or do you need 5 minutes with him, just to make sure he's presentable?
If we could have a few minutes with him, once he gets here, just that way, because I've got his shoes and a tie
All right.
ready for him.
Then we'll open the jury now.
Do you want to do the police first, Judge, before we start the trial?
Yes. Lord, we do the civil trial.
I haven't heard anything. I will double check with that to make sure.
No news is good news.
Yeah, I will double check with her to make sure.
Yeah, Your Honor, we'll also have some stipulations on the record.
You should.
Who's gonna be your case agent?
Detective Marcus McNeil, Judge.
Okay.
What's his last name?
McNeil.
McNeil.
You'll see it.
N-E-I-L.
Is it detective?
Yes, ma'am.
Okay. Oh, okay, yeah, we don't want to go down. Everything good to care.
He's got two sets of dress clothes, actually. He refused to dress.
Oh.
So.
Thank you. You have a magic touch. Like you.
How long do you expect the case to take?
I would say at least a week, Judge.
At least a week or a week?
I would say at least a week.
Okay.
I think this week.
I think just a week, okay. So, huh?
I'm not looking.
I know you're not. So, we will go to 4 today. And, we will go to 4 every day, but, today we'll definitely go to 4. And tomorrow I will take a lunch break between noon and 1:30. So, I mean, actually noon to 1:30, because I have a mandatory training that I have to attend noon to 1:30. The Supreme Court is coming in. We all have to be there, so 12 to 1:30. So tomorrow will be lunch 12 to 1:30, okay?
Judge, do you think it will start before noon tomorrow?
Absolutely. Yes, I didn't have to look, we don't have anything on the docket tomorrow, do we? Because if we don't have anything on the docket tomorrow, we're starting at 9. And, well, let me say, but maybe, because I know that you all probably have other cases you gotta handle.
Just to move dates,
Probably.
that's it.
Okay, so if you want me to start, before 10, I can. If not, I'll start at 10. It's up to you.
Yes, I think 10, Judge, I think 10 would work.
Okay,
That would give us enough time to,
move some stuff.
yeah.
Are you gonna give them a lunch break today?
Yes,
Okay.
and I never know what time until we get started. So probably, yeah, I gotta get them in here. So we probably won't take lunch until 12:30 today, just because they've been upstairs and then tell them to go to lunch. They kind of don't like that, so at least they wanna come to the room and see what's going on, so they're already out. All right, so let me ask you this. Do you want just to do the please now and then start after lunch?
I don't care.
We're fine either way, Judge.
Okay, so
Whatever
you
you
fine
want.
with taking lunch at 12:30?
Yeah, I'm fine with that. Are you good?
That's
Yeah.
fine.
All right,
I think that, like you said, they can get in here and.
so let's, go ahead and, tell Brad that I'm gonna be bringing him down probably by 5:30. Okay? return on streaming during jury selection. I asked. Yeah, she's in charge. No, yes.
There's an argument I took up, the transcript of the book saying she's busy.
Yeah.
That's what I four page transcript, so I just.
Their house has statute of limitations. I've never liked one, there's a great. Have you?
There's too many like doctors, nurses, pediatrician, teachers, yeah.
Protectors.
Mhm.
The victim's rights attorney filed a motion for honesty to be present in the entire trial. So we're gonna have to deal with that.
Okay. When did she file that?
She may have filed it when.
She filed a bunch of them, like 2 or 3 motions
Yeah.
when she first got on there, and nothing since.
Are you guys
It's
gonna
kinda
object to that? Amy? Because she testifies first. You still want to object to it?
So you do the rest of the trial?
Yeah. And I've asked her for a picture of Christopher and Mike, but I haven't got one yet, so.
Okay.
I think it depends on if she can control herself. I mean, if she's sitting there moaning and crying, putting pictures up, I think that's super prejudicial.
I don't think I would want to.
No, I mean, it was confusing to do that. But I mean,
But, I mean, we did my babies.
Is her attorney here?
It's a girl with long curly hair.
so we're gonna sit back.
They went to go talk to her. Are they bringing him down as he close?
Supposedly. I love Mercy.
I think
you guys
that-
weren't doing that stuff already.
I think the sentiment is good, and maybe there are other counties that weren't doing that stuff.
I mean, you guys have a whole victim rights, like for victims advocate.
Right, right. So, I don't know. Kind of walking pretty far away. So I don't want to leave you guys.
We gotta be sure.
The supervisor. Yeah, so I'm standing there and I'm checking in. She said, "What's the last trial today?" And I said, "I don't know if you're she's like, "It's everything." She was over texting me. I said, "Well, these are the ones that came us." Yeah, so she goes, she goes, "This is the one I opened the bag and then they hit me in the face." And I was like, "Yeah." And she goes, "Check is closed through." Like, yeah. I was like, "Thank you." Stephanie was great. She let me like above the elevator. I think I'm so great. It's like how good she's been with quality.
She's great. That's right.
Yeah, I've got like 7 or 8 pairs of shoes, questions, sitting in a box. With a name to it.
Somebody's realized that they were checking this.
I also have a box of like 15 cell phones from my federal claim, and that's just dropped off in the lobby. After he said this. obviously.
I have my phone, just text me when you want.
Yeah, but there's shoes. And a caution.
Sure.
Yeah, we're gonna do the gun police.
I was informed that you were working on gathering jury instructions. Is there a way to access those? We have a jury trial this week. I'm just trying to get some jury instructions to that. Judge classes. I did not. Oh, group text.
Yes.
Okay, so I was aware of being set up crosswalk, but I don't have access to the
I'll send it to you.
Thank you so much. We did just crosswalk in a break standard. Yes. All right, thank you so much.
Does anybody know who the prosecutor is?
I know she stepped out to give us a moment to talk, but I texted her.
I just talked to him.
She's walking right here. Now you're over.
I just talked to him. He said, yeah.
These are the matters of State of Ohio versus Leandre Glenn, case number B210-3303 and B210-2474. Mr. Glenn is present in the courtroom with his attorney, Mr. Brad Fox, and Ms. Angela Glaser, and Ms. Mary Poston for the State of Ohio. This matter is set in both of these matters for jury trial. But it is my understanding that there has been an agreement reached in case number B210-2474 that will resolve the matter, and an agreement in B210-3303 that will partially resolve the matter as to counts 4 and 5, and then the matter will proceed to trial on the remaining counts 1, 2, and 3. So, is this how your client wishes to proceed today, Mr. Fox?
Yes, Your Honor, he's prepared to enter a guilty plea to the B210-2474, both counts 1 and 2, and to counts 4 and 5 of the B210-3303 case number.
All right. Is that accurate, Mr. Glenn? All right. Are you the Leandre Glenn named in both of these indictments? How old are you?
23.
How far did you go in school?
Graduated high school.
So you're able to read and write the English language well? I have in my hand 2 identical single-page documents. They are entitled Waiver of Trial by Jury. And one is for case ending in 3303 and one ending in 2474. At the bottom of each page, there are signatures. And I recognize Ms. Glaser's signature on both of them, here and here, and Mr. Fox's signature here and here. But up here, right above, on both sheets, are these your signatures?
They are.
These are acknowledgments by you that you understand you have a constitutional right to have a trial as to case ending in 2474 and as to counts 4 and 5 in case numbers 3303. Do you understand? But when you sign these forms, you're indicating to the court, I understand I have a right to a trial, but I don't want a trial as to this case and these counts. And so I'm waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed these forms? Did you sign these forms after consulting with your attorneys about your constitutional right to a trial?
Yes, I did.
Do you have any questions about these forms?
No.
Do you have any questions about your constitutional right to a trial?
No.
I also have in my hand 2 identical 3-page documents entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page of both of these identical forms, there are signatures. I recognize Ms. Holston's signature here and here, and then your Ms. Glaser's signature and Mr. Fox's signature here, Ms. Jared Fox's signature here and Ms. Blaser's signature here, but up here, is this your signature where it says signature of defendant?
No.
And on this document, is this your signature where it says signature of defendant?
No.
All right. Madam Prosecutor, would you please put on the record the party's expectation regarding the pleas?
Judge, regarding case B 210-2474, I expect that Mr. Glenn will plead guilty as charged to both counts. Regarding 210-3303, I expect that Mr. Glenn will plead guilty as charged to counts 4 and 5, and leaving counts 1, 2, and 3 for trial.
All right. Is that accurate, counsel?
It is, Your Honor.
All right. Is that your understanding as well, Mr. Glenn? Now, are you under the influence of any medications, alcohol, or drugs today?
No, ma'am.
Do you now, or have you ever had to manage any type of mental health difficulties?
No.
Are you presently under any type of probation or community control supervision in this or any other state?
No.
Has anyone forced, threatened, or coerced you in any manner into entering into these pleas of guilty today?
No.
Has anyone promised you anything at all if you enter into these pleas of guilty today?
No.
Are you making these pleas of your own free will?
No.
Now, the state has indicated in case B210-2474, it's a 2-count indictment. Count 1 is carrying a concealed weapon, a felony of the 4th degree. Count 2 is improper handling of a firearm in a motor vehicle, a felony of the 4th degree. The state has indicated that it's expected that you would plead guilty as charged in that indictment. Is that true?
No.
Is that what you talked with your lawyers about before this hearing today?
No.
And with regard to case B210-3303, it's a 5-count indictment. And it's my understanding, as outlined by the state, that you're going to enter a guilty plea to count 4 and 5, which is carrying a concealed weapon and improper handling of a firearm in a motor vehicle, both felonies of the 4th degree. Is that true?
No.
Is that what you talked with your lawyers about before this hearing today?
No.
Did you have an opportunity to review both of these 3-page plea forms, which are identical, with your lawyers before this hearing today?
No.
Did your lawyers answer your questions?
No.
Do you have any questions right now about them?
No.
Do you understand what they say?
No.
Mr. Glenn, do you believe you've had enough time to fully consult with your lawyers about the 2-count indictment and ending in 2474 before this hearing today?
No.
And have you had enough time to fully consult with your lawyer about counts 4 and 5 of case ending in 3303 with your lawyers before this hearing today? Have your lawyers answered all of your questions with regard to this case and these counts to your satisfaction? Have you had an opportunity to review the evidence that the state has against you with regard to this case ending in 2474 with your lawyers before today? Have you had enough time to, and have you reviewed the evidence with regard to count 4 and 5 of case ending in 3303 with your lawyers before this hearing today? Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge with regard to the 2-count indictment and the count 4 and 5 of the 5-count indictment?
Yes, Judge, discovery has been completed with cases.
All right. Counsel, do you acknowledge receipt of same?
Yes, Your Honor.
All right. Mr. Glenn, are you satisfied with your lawyers? Now, do you understand these charges against you? So in both of the cases, they are identical charges. Carrying a concealed weapon and the first count, or count 4 in the other case, and improper handling of a firearm in a motor vehicle in count 2 and count 5. Do you understand those charges against you?
No.
Do you understand that if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in counts 1 and 2 and count 4 and 5?
No.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? Now, counts 1 and 2 of the one case and count 4 and 5 of the other being identical charges, they're all felonies of the 4th degree. Do you understand that you are facing up to 18 months on each count and up to a maximum fine of $5,000 on each count? Do you understand that if I sentence you to prison on these counts, upon your release from prison, you could be on post-release control for up to 2 years? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand? Are you on post-release control right now? Do you understand that if you are on post-release control and you commit a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term, or whatever time remains on your post-release control time, or whichever is greater. Do you understand that? Do you have any questions? Because these are felonies of the 4th degree, just the counts that we're talking about today, community control is a possibility. Do you understand that I could place you on, I have the authority to place you on community control for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions of community control, you'd be brought back before me for a more restrictive sanction, which could include a whole host of penalties. The most severe penalty could be the imposition of prison time up to 18 months on each count. Do you understand that?
No.
Do you have any questions? No. When you plead guilty, you give up some very important constitutional rights, and I need to make sure that you understand. Do you understand that you have a constitutional right to a trial, either to the court or to a jury of 12 persons? Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyers?
No.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself? Do you understand each of these rights as I've explained them?
No.
Do you have any questions whatsoever about your constitutional rights?
No.
Do you have any questions whatsoever about anything we've discussed?
No.
Do you understand that if you plead guilty to these offenses, you are making a complete admission and you are waiving all of these important constitutional rights? Knowing everything the court has discussed with you this morning, do you still wish to enter a guilty plea as charged in counts 1 and 2, in case ending in 2474?
No.
And do you wish to proceed and enter guilty pleas as to count 4 and 5 in case ending in 3303?
No.
Counsel, is there anything further before I accept the pleas?
No.
All right, may I hear a statement of facts?
Yes, Judge, on the case B 2102474, count 1, Leandre Glenn, on or about May 11th, 2021, Hamilton County, State of Ohio, knowingly carried or had concealed on his person or concealed ready at hand a handgun other than a dangerous ordinance, and the weapon involved was a firearm that was either loaded or with ammunition ready at hand in violation of section 2923.12A2 of the Ohio Revised Code. Facts on count 2, Leandre Glenn, on or about May 11th, 2021, Hamilton County, State of Ohio, knowingly transported or had a loaded firearm in a motor vehicle in such a manner that the firearm was accessible to the operator or any passenger without leaving the vehicle in violation of section 2923.16B of the Ohio Revised Code, both felonies of the 4th degree. And I don't think this is on the plea form, but there is a forfeiture specification for a Springfield XP 9mm handgun. The property that was used in the commission of counts 1 and 2, we would ask that the court grant that forfeiture specification and forfeit the firearm.
All right, is there any objection to the forfeiture of the firearm in case B2102474?
No.
All right. Mr. Glenn, did you hear what the prosecutor said you did?
No.
And this is in 2474. Is it true?
No.
What is your plea, to count 1, carrying a concealed weapon, a felony of the 4th degree?
Guilty.
What is your plea to count 2, improper handling of a firearm in a motor vehicle?
Guilty.
Is there?
Of the second one, this is case B2103303. Count 4, Leandre Glenn, on or about June 26th, 2021, Hamilton County, State of Ohio, knowingly carried or had concealed on his person or concealed ready at hand a handgun other than a dangerous ordinance, and the weapon involved was a firearm that was either loaded or with ammunition ready at hand in violation of section 2923.12 A2 of the revised code, a felony of the 4th degree. Count 5, Leandre Glenn, on or about June 26, 2021, Hamilton County, State of Ohio, knowingly transported or had a loaded firearm in a motor vehicle in a manner that the firearm was accessible to the operator or any passenger without leaving the vehicle in violation of section 2923.16B of the revised code. I would also ask for a forfeiture of that firearm. All right.
Nothing as to the facts, and Your Honor, we will stipulate to the forfeiture.
All right, thank you. Mr. Glenn, did you hear what the prosecutor said you did in that case?
Yes, ma'am.
Is it true?
Yes, ma'am.
What is your plea to count 4, carrying a concealed weapon, a felony of the 4th degree?
Guilty.
And what is your plea to count 5, improper handling of a firearm in a motor vehicle, a felony of the 4th degree?
Guilty.
Let the record reflect that Leandre Glenn was present in court with his attorneys, Mr. Brad Fox and Ms. Angela Glaser, and that Mr. Glenn was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Glenn understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding them to be voluntary, the court accepts the guilty pleas and finds Leandre Glenn guilty in case B2102474 as to count 1, carrying a concealed weapon, a felony of the 4th degree, in violation of revised code 2923.12 subsection A2, and guilty as to count 2, improper handling of a firearm in a motor vehicle, a felony of the 4th degree, in violation of revised code 2923.16 subsection B. There will be a forfeiture of the firearm in that matter. With regard to case ending in, case B2103303, the court finds Mr. Glenn's guilty pleas to be voluntary and accepts those guilty pleas and finds Leandre Glenn guilty as to count 4, carrying a concealed weapon, a felony of the 4th degree, in violation of revised code 2923.12 subsection A2, and guilty as to count 5, improper handling of a firearm in a motor vehicle, a felony of the 4th degree, in violation of revised code 2923.16 subsection B. The firearm in that matter will be forfeited as well. All right, so counsel, is there any reason why a sentence should not be entered on case ending in 2474?
Other than, because we don't have the outcome of the other matters in counts 1, 2, and 3.
Well, I'm talking about the other case, not the one we're going to trial on. The case ending in B 2102474, can be closed out today. It carries a penalty of up to 18 months. Mr. Glenn has served more than 18 months.
Yeah, sure.
And so, do you want to proceed?
Yes, sure. We'll proceed to sentence of the David Wade PSI as to the B 2102474 case.
All right, state. You have an objection to me closing that case out? We still have the case for the trial.
No, I don't, Judge, not at this time, I would defer the court.
All right, thank you very much. All right, is there anything you want to say on behalf of Mr. Glenn? I'm prepared to sentence him.
No, Your Honor.
All right. State, anything you want to say?
No, Judge, defer to the court.
All right, Mr. Glenn, anything you want to say with regard just to the case of where there's 2 counts, you've been convicted of carrying a concealed weapon and improper handling of firearm in a motor vehicle? All right. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've reasonably calculated this sentence to achieve the 2 overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. Additionally, I consider the seriousness and recidivism factors set forth in revised code 2929.12. Accordingly, as to case number B 2102474, Mr. Glenn, I hereby sentence you to a term of 18 months in Ohio Department of Corrections with credit for time served, 612 days. I have to notify you by law of the post-release control time, which is which may be up to 2 years. The firearm is forfeited because you've been in custody the entire time. Costs and fines are remitted. All right, with regard to the other case, that will just be in abeyance until we finish with the counts 1, 2, and 3. Okay? All right. So are we ready to bring the jury down?
Your Honor, if we could play some things of record.
Yes.
We do have stipulations in this case.
Okay.
In speaking with the state of Ohio over the past week, we've come to 3 stipulations. One is there are phone records that show communications between Mr. Glenn and Honesty Jones, another victim in this case. We will stipulate to the authenticity of those communications, that there are records showing that they were communicating that day, to save having somebody from the phone company come in and submit that record.
All right.
Wait a minute, you're stipulating to that,
Right.
right? Okay. Judge, this is actually a summary of the phone records.
What exhibit is it?
I haven't marked it yet.
Okay.
It is, sorry. It's the summary of the phone records that I was going to enter into evidence in lieu of the entire phone record, in case there is something prejudicial. It's actually to benefit the defendant so that there's nothing prejudicial that the jury may see that may have been on his phone.
All right, so once that is marked and there's a number, then I will just make the record clear that there's stipulation as to that number. But I will receive that stipulation by the defense of the summary of the phone records as to authenticity and admissibility. Okay.
Your Honor, the next stipulation that we've entered into with the state of Ohio is there's a video from Penn Station that shows Mr. Glenn going in, getting food, and leaving. Instead of having somebody from Penn Station come and authenticate that video, we stipulate to the authenticity of that video and its admissibility.
All right.
And the stills from the video as well?
Yes.
So not only the video, but also still photographs?
That show him, they're excerpts from the video.
Is there, do you already have that marked yet?
I don't have any numbers yet, Judge.
All right.
Your Honor, lastly, we have a stipulation, there is a video from Children's Hospital that shows Mr. Glenn coming and going on the date that the child was admitted to the hospital. We would stipulate to that video so we don't have to have somebody from Children's come down and say, yes, that's our security video.
And I would note that I have made a new copy of that video, and I will provide you with that. It's essentially a trial copy, so there aren't so many camera angles.
Yes.
But it is from the raw video. So there's that video, and then there's stills, Judge.
All right. And so when they are marked and there's a number, then I will be sure to make the record clear so that it is as to that stipulation, but I will receive and accept that stipulation at this time.
Your Honor, I believe at this time that is all the stipulations that we have with the state of Ohio regarding the admission of evidence. We do want to place on the record that there have been plea discussions and negotiations back and forth in this case for a number of months. Where it was left is the state of Ohio made an offer of 17 to 22 and a half years given Reagan Totes. That we have presented that on multiple occasions to Mr. Glenn, that he countered to the state of Ohio with a plea offer of 15, that they have held firm at their offer of 17 to 22 and a half on an involuntary manslaughter with other to get to that number with the other charges that we have. Mr. Glenn does not want to accept that on counts 1, 2, 3. He does want to proceed toward trial.
All right, so if I hear, is that accurate?
Judge, at one time I did offer that. He has since counter-offered. I would have to talk to my detective as well as the mother of the victim as to whether or not we can still accept that.
All right, so what we have here is some negotiations to resolve this matter short of a week and a half long trial. And the penalty, if Mr. Glenn is convicted, is life imprisonment.
Correct.
And the offer by the state and the counter by the defense is basically a matter of 2 years.
Yes, Your Honor.
All right, but the state, I am going to ask you to talk with, the detective and the victim before we enter into a very long trial that could go either way. Either way. It can come out guilty and it can come out not guilty. So I'm gonna ask that you, the state, just to take a few minutes, if you wouldn't mind, to talk with the victim's mom and the family and the detective, and then come back and let me know. Okay? And what we're going to start getting the jury together. She really did great. So this way. So.
I knew you would be able to do that.
It doesn't really work with Lord.
I know you don't have cameras to see it. Look at her, Chris. Chris. I need to let you. I saw you. And he's like, I'm not going to suit. I had like sunglasses, so I go. Like, he was like, no.